Welcome to our insurance webinar. By way of introduction, I'm Virginia Hickley. I'm an insurance partner, ordinarily based in our city office, but currently streaming to you from home in North London. I've been with the firm for coming up to 18 years and an insurance partner at Mills Reeve for just over 12 years. Over the years, I've dealt with a broad range of work, but in recent years, my specialisation has been on defending claims and dealing with coverage issues in relation to financial professions and institutions. Today, I'm joined by my colleague, Sara Hunter. She's 12 years qualified and has been with the firm in the London office for 9 years. Sara advises on a wide variety of policies, including general liability and international property work. Her work also includes subrogated recovery. So between the two of us, we have over 30 years of experience in interlocking but different areas, and we'll bring that experience into our talk. The talk will last 15 minutes and it is recorded. Because it's a webinar, we can't see you or hear you. So please do use the Q&A function as we're talking to ask questions, and we'll do our very best to answer them at the end of the session. And if we run out of time, we can always carry on the conversation privately by email. So what are we going to talk about today? Up on the screen are signposts around the next 15 minutes of content. And today is all about the Third Parties Rights Against Insurers Act. What it is, how it works, why does it matter anyway? And then some recent cases, both through the courts and case studies from personal experience from each of us over the last few years. So you can see the Act's application in practical, not just theoretical terms. But before I move on, we have a question for you. There should be on your screens a poll that pops up. We'd like you please to vote using that poll. Right. So,
interesting.
A significant number of you are not dealing with the Act. So this talk is relevant to 16% of you, 84% of you. We believe will become increasingly relevant to you. If you're not currently dealing with it, perhaps some of you are not familiar with this at all. Not to worry, because Sara is going to take you through the nitty-gritty of the Act now. Over to you, Sara.
Thank you, Virginia. Next slide. Today we're going to talk about the Third Parties Rights Against Insurers Act 2010. Although it is called the 2010 Act, it was amended by the Insurance Act 2015 and the Third Parties Rights Against Insurers Regulations 2016, which came into force on the 1st of August 2016. Any claim before this date will remain under the 1930 Act. So, first of all, the Act, what is it for? What does it do? The burning question, if you like. The 2010 Act transfers an insurer's right under an insurance contract to a claimant. A potential claimant who wants to claim against an insured can effectively step into the insured's shoes and claim directly against insurers. The problem with the 1930 legislation, which we'll come on to later, is essentially that it did not have to keep pace with the changes to the insolvency regime. So the new legislation has come in by virtue of the 2010 Act in order to address those deficiencies. When the 1930s Act was brought in, the proceeds of an insurance policy would have been required to be paid into an insolvent estate and then administered to creditors in the usual way. So the point of the 2010 Act is to enable a claimant to pursue its claim directly against insurers. By bypassing insolvency legislation, you create a shortcut for beneficiaries of an insurance policy. This allows recoverability of the claim as opposed to on a pro rata dividend basis from the insolvent estate. The key difference and one of the main benefits of the 2010 Act is that you do not have to reinstate a dissolved company to the register before suing it. You can sue the insurer direct. Next slide. The key provisions of the Act are that a relevant person, the tortfeasor or the insured, must incur a liability against which there is insurance, or an insured person having incurred liability becomes a relevant person. A relevant person can include an individual or a legal entity such as a company. It can include a situation where an insured is not yet insolvent, but has gone in administration, for example, a voluntary arrangement. The rights of a relevant person are transferred from the insured and vested in the claimant to whom the liability was and is incurred. The claimant can bring direct proceedings in respect of those transferred rights against an insurer without needing to prove liability yet. Obviously, it cannot be enforced at this stage. So in other words, the arguments relating to cover and the arguments relating to liability are lumped together in the same action. Critically, the Act removes the previous requirement to have the company restored to the register. And in order to enforce that liability, it must have come to a head somehow, resolved by an arbitration award, a trial, a judgment, employment tribunal, settlement, or a court declaration. Next slide. So why does this matter? Well, Britain is experiencing a COVID-induced or a Brexit-induced recession, as I'm sure you don't need me to tell you. When the economy takes a tumble, this will mean more insolvencies and a spike in claims, many of which will be insured by you. Because a greater number of businesses are going to go bust or into a voluntary arrangement, claimants are going to be requesting policy details and will want to know if there's cover so that they can sue the insurer directly. The changes make it quicker, simpler, and cheaper for claimants to obtain payments from insurers. However, it's not all bad news. Now insurers can scrutinise the claims against the insured rather than being presented with a bill at the end once judgment has been obtained. This allows insurers to get a proper crack of the whip when it comes to invoking the defence and hopefully ensuring more control. Now we're going to run through some cases, all post-2016, some of which may offer comfort to insurers. Given that we have 15 minutes, we won't go into the detail on those cases, just a flavour in order to give an illustration to insurers how best they can manage their cases on both liability and cover, and also circumstances when they do and don't have to hand over policy information. Okay, so without further ado, I will hand you over to Virginia, who will talk you through those cases that deal with some of those questions.
Thank you, Sarah. The BAE Systems case seems like a good place to start because it shows the new law in action after the 2016 changes, which Sarah's just taken you through. In this case, a third party joined an insurer as a co-defendant. Previously, a claimant would have just restored the insured company to the register, sued, and then found out after the event whether cover was in place. For the insurer, the old days was like a sort of game of cat and mouse as to whether to reveal the policy and reveal that coverage wasn't there. If advice on cover was borderline, then as a defence lawyer, you had to decide how to manage it. Should you say what the issue is and hand over the policy? Should you continue to defend it and then ambush the other side at mediation? Obviously, if the claimant believed there was no cover, then it might put them off suing. However, they're not going to meekly walk away without seeing the policy. On the other hand, if you let the claimant see the policy, you can be sure that any slightly dodgy coverage points would be vulnerable to challenge. Another issue to think about was the timing. When should you reveal the fact that there's no cover to the other side? If you do it too early, then there's a risk that the claimant would amend its claim to bring it within the terms of the cover. Canny claimants always ensure that the words like fraud and dishonest are nowhere in a claim they might bring for negligence, contract, breach of trust, for example. Obviously, those would be safe, whereas dishonesty and fraud would be excluded under the policy. So sometimes they do this despite the facts making it blindingly obvious that the insured had behaved dishonestly and wasn't deserving of the cover of the policy. For the claimant, it was more like a game of lucky dip or Russian roulette. There was a risk that after incurring significant cost to bring the claim and litigate it to trial, any victory would be Pyrrhic. Claimants would be led into a fight up the garden path and then beat the defendant, only to find that the prize was an empty wallet. An insolvent insured may or may not have cared about the outcome. In professional indemnity, there might have been a professional reputation to defend, even if the insured firm or company had gone under. There might even have been a chance of success. The threat of no cover could sometimes be used to negotiate a good deal where liability defences were poor, and yet a claimant had no right to a sneaky peek of the terms and to challenge them without taking the case to trial, at which point all would be revealed. In this case, the BAE case, Mrs. Justice O'Farrell found that a third party may join an insurer to the litigation as a co-defendant if there is a coverage dispute. Once the insured is insolvent, the claimant can request the terms of cover, and the insured and insurer can be sued at the same time, partly on liability and partly to argue that the claim is covered. We'll come to later what they can ask for on the policy. This change should be welcome for insurers. I mean, yes, it makes it all the more accessible for claimants, but actually it is cheaper to have the whole thing streamlined in this way. As Sara pointed out, it avoids two sets of proceedings. One issue that this law throws up is that insurers are going to have to think about their choice of lawyers. If they can be sued on liability at the same time as on cover, they can have only one set of lawyers on the record defending insurers' position on both. Sometimes it can be tricky for an insurer dealing with an insured that's about to become insolvent to decide at what point they should merge lawyers and which lawyers to use. They'll need to think about whether the case is best fought on liability or policy defences. The next case is Palliser. This is the one to cite when you're making the point that the rights granted to a claimant are no better than the terms and conditions of the policy. In other words, if insurers wouldn't provide cover to the insured, then they don't cover the claim from a third party who's just stepped into the insured's shoes where the rights have been transferred under the Act. It may seem like an obvious point, but I guess it can't be that obvious or we've gone to trial. In Palliser, Recorder Burrows QC, before he was promoted to High Court judge, considered the liability of an insurer of a landlord to compensate a leaseholder following a fire in a restaurant. However, the policy contained an exclusion for property that was belonging to or in your charge or under your control. As a matter of construction, the building did belong to the landlord, and so the claim failed. Another example that we've come across in our practice is when an insured has breached a policy term which would allow insurers to avoid. For example, an insured who's not given the insurers a fair presentation of the risk before the contract of insurance has been entered into. However, some exclusions won't wash. In the bad old days before the changes, there used to be a paid to be paid provision. For example, where a policy stated that the insurer didn't have to pay out until the defendant had done so. It's pretty tricky if you're insolvent, and that won't work anymore. You also can't rely on a failure by the defendant to provide information or assistance to the insurer. For example, because the defendant has died or been dissolved. The only exception there with the terms and conditions is that a claim must still be notified if that is a requirement of the policy. So the claimant simply steps into the shoes of the insured to notify if the insured hasn't done it. This last case, Peel Court in Dornoch, was decided by Mrs. Justice Jefford. It's useful because it clarifies when insurers have to hand over policy information. The Act is clear that they must where the insured is insolvent. However, a claimant has no express right to obtain a copy of the insurance policy where the defendant is still technically solvent, even if arguably unable to pay the claim. Nor can they use pre-action disclosure to obtain disclosure. Mrs. Jefford said it would be curious if a potential third party could have disclosure of an insurance policy under CPR 31.16 by arguing that the solvent insured might at some point become insolvent. However, once an insured is insolvent, the claimant can ask for pre-action rights to insurance information. It's not disclosure, it's Clause 11, Schedule 1 of the Act. They can ask for who the insurer is, terms of the contract, whether the defendant has been told the insurer has pulled cover, i.e. whether there's any coverage dispute in place, and they're entitled to know the limits, deductibles, fixed charges, essentially anything that would affect recovery. The information can be requested from the defendant and any third party. So, for example, that includes the broker. The information must be provided within 28 days. So we've been talking for 15 minutes now. Thank you for listening. We do have time for some questions, which hopefully you've been typing into the Q&A section as we've been talking. My colleague Harriet Strevens has kindly agreed to sift through the questions. Harriet, if you don't know her, is our professional support lawyer who makes sure that we in the team are not only up to date on the law, but also that our content is relevant to clients' business. So no doubt she'll want to be in touch with you afterwards. Are there any questions, Harriet?
Yes, we do. Thank you very much indeed, Virginia. My first question, which you may like to address, Virginia, is what happens if you're a broker and you receive a request from a potential claimant or their lawyers for information about the policy? Brokers would normally only respond to their client about policy details. Do you have to reply?
Yes, in a nutshell. I thought I might get a question on that. It's if you don't reply within the 28 days, I mean, often a broker will check that, if you like, the defendant's lawyers aren't getting the same question and dealing with it. But if they really are the only person with this question, facing this question, and they don't reply within 28 days and don't comply with it, then yes, they can face a court order eventually, yeah.
Thank you very much.
I think I'd also add, if the broker does get requests, and we've got any brokers watching, they're always just to check with the insurer as well, just that, because they always have to establish that the insured is actually insolvent. So always worth just run it past insurer as well.
Thank you, Sarah. Another question, Sarah, you might like to address perhaps, is can you decline cover for a claim if the insured doesn't cooperate?
Well, technically you can, and this is an argument which sometimes insurers may, in my experience, in some of my cases, insurers may have felt the need to threaten where there's a lack of cooperation, but we've never had to go as far as to take a policy coverage point. I think my feeling is it would be quite difficult to pull cover on that basis, particularly if the insured is insolvent, has lost its business, and that there may be other reasons as to why they're not communicating with us. So I don't know what your thoughts are, Virginia. Have you come across this point?
Well, I have had a situation where the insured didn't cooperate before they went under, and then once the claimant took over under the Third Party Rights Act, that they then tried to cooperate, and so insurers wanting to sort of pull cover wouldn't then work, I don't think.
We have a question from an anonymous, which is on point actually. The question is, does an insurer have to accept a notification from a third party where the insured is insolvent, or do we have to insist on a notification from liquidators?
Yes, it should go through the liquidators, but if the liquidators don't do it and the claimant does, I think the court would find it pretty difficult to say that it hadn't been notified under the terms of the policy in that situation.
We have, in the same way that our attendees come in bunches, now quite a few questions, and so perhaps I'll finish on a short question and the others will be dealt with, if we can, by email. One of the questions we've been asked is, will we receive a copy of the slides, please? I think the answer to that is yes.
Yes, that's and we'd be really grateful, wouldn't we, for some feedback, because I think that's going to come out with what follows after the talk.
Yes, right. Unfortunately, we're running out of time to deal with any more questions if we want to confine ourselves to our successful 15-minute session. But before we sign off, there are a couple of things I would like to mention, if I may. The first thing is that next week's webinar on the 1st of October will cover the Financial Ombudsman and will be hosted by Matthew Wilson and Claire Loveday. The second is, please do fill in our feedback form. It will follow the conclusion of this session, and feel free to include any topics that you would like us to consider addressing in future webinars. Finally, as I say, we will deal with as many of the questions by email as we can, but thank you very much indeed for joining us this morning, and we hope you found the session both interesting and helpful, and wish you a very good rest of the day. Thank you very much.